Oyez, oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Be seated, please. Case number 23-3005, United States of America, Troy Sargent, Appellant. Ms. Minzer for the Appellant, Mr. Hennifer for the Appellee.
Good morning, Your Honors, and may it please the court, Judith Meisner representing the appellant Troy Sargent. The issue in this case is whether the district court erred in applying the guideline for aggravated assault, 2A2.2, rather than the guideline for obstructing or impeding officers, 2A2.4, to Mr. Sargent's conduct of swinging an open hand towards a Capitol police officer and making contact with that officer, 30 seconds later swinging an open hand again, intending to hit that officer, but hitting somebody else. There were no injuries. He was convicted of violating 18 USC section 111, which is forcibly assaulting, resisting, opposing, impeding, intimidating, interfering with officers in performing their official duties. And where here, the application of the aggravated assault guideline was based on the commentary definition of aggravated assault, which includes assault involving the intent to commit another felony. Here, that felony was civil disorder. Mr. Sargent argued below and maintains here that the aggravated assault guideline did not apply to his minimal contact. Aggravated assault is not defined in the text of the guideline. It is defined in the commentary to the guideline as meaning a felonious assault that involves a dangerous weapon with intent to cause bodily injury with that weapon, serious bodily injury, strangling, suffocating, or attempting to strangle or suffocate, and an intent to commit another felony. We submit that no deference is due to the commentary definition because it includes assault with intent to commit another felony.
When the guidelines were first drafted in 1987, this aggravated assault guideline 2A2.2 was a part of that initial package.
Yes.
And that package was sent to Congress. And my understanding is that the commentary that defined 2A2.2 was part of the package that was sent to Congress. And that commentary at that time included the language, an aggravated assault is an assault with intent to commit another crime. If all of that is true, Congress reviewed the guidelines and approved them, and it would have looked at the commentary in determining whether to approve that guideline, just like anybody else would look at the commentary to try to figure out what that guideline is supposed to mean. Shouldn't that impact how or what type of deference we give to that commentary?
Well, the statutes don't require commentary to go through either the notice and comment and notice rulemaking or congressional review. We don't know what Congress did when it received, we don't know exactly what Congress looked at or how they viewed the commentary at the time that they reviewed the guidelines. So I think that the standard is still for reviewing whether deference is due to commentary are the cases in which the Supreme Court has defined and discussed that deference.
This commentary, in addition to the points Judge Wilkins made, did go through notice and comment process. Published in the Federal Register, comments received. It went through in fact, virtually all commentary has since 1997, post-Stinson. So how does that affect? I mean, there's a lot in your briefs about sort of a Kaiser analysis, but we are talking now about a notice and comment rule, the equivalent of a notice and comment rule.
Well, it's still, we still don't know exactly what how Congress viewed the commentary. I'm not
We
aware.
don't know how they viewed the guidelines, other than they chose not to change them, and yet that does not affect our standard of review. We don't require, before applying the Stinson standard of review, that there be affirmative evidence that Congress looked at the particular commentary or even guideline. That's just the nature of the legislative process.
Well, I would point to the 4 circuits that have held that Kaiser does apply.
How many of them have held that it applies, notwithstanding that the commentary went through notice and comment process?
I don't believe that those cases have discussed that
Right,
particular.
so I don't know whether the particular commentary at issue in those cases went through notice and comment. Of course, there are many circuits who have rejected the Kaiser approach anyhow, but here we know that this one went through notice and comment, so it would seem quite unusual then to try to stuff it into the Kaiser bag.
Well, even if it went through the notice and comment process, there's still a question of whether or not the commentary is reasonable. And I think that the same issues that Kaiser raises in discussing ambiguity, in a sense, are relevant here as well.
So can I ask a question about what the ambiguity is here, sort of separate and apart from any deference questions? I'm curious what your answer is in particular to the statutory index reference for 113A2.
Well, 113 has a number of different provisions.
Right, and one is
And-
very specifically assault with intent to commit another felony. And then the statutory index, which is part of the
Right,
guidelines,
to
not
a-
a commentary, refers to the aggravated assault, not the simple assault
Well,
guideline.
There are some kind of incongruities between 113 and 111. 113 imposes a higher maximum penalty for the assault with intent to commit a felony than 111 does. It's 10 years as opposed to 8. 113 imposes a lower maximum penalty for assault by striking or beating or wounding than 111 imposes for assault with physical contact. It's 1 year as
But
opposed to 8.
if all I knew about this case was that 113A2 is assault with intent to commit another felony, and that the index deems that aggravated assault, isn't that very powerful evidence for the government's position?
It may be some evidence, but given the distinctions between 111 and 113, and 111 is the statute we're dealing with, I don't think that the fact that for 113, the Sentencing Commission imposed the aggravated assault guideline would be controlling.
Yeah.
It's
And then I just had one question about 111, because I understand your argument to be 111 groups together assault with physical contact and intent to commit another felony.
Mhm.
But if we actually looked to 2A2.4 for assault with intent to commit another felony, it would actually be treated the same as simple assault, right?
No, simple assault is 2A2.3. Assault 2A2.4 has a higher base level because you are talking about an official, and it has enhancements for physical contact and dangerous weapon and bodily injury. 2A2.3 is assault.
I apologize. The point, I think, is that under 2A2.4, there's no increase, right, for if the assault is with intent to commit another felony.
That's built into the base offense.
But you say it's built into the base offense, but if the assault to commit another, with the intent to commit another felony involves striking, as in here, then it's the exact same as if, well, I guess your point is that it's a base offense level 10 instead of in
Either
2.3, it's 7
or 4.
or 4. But I guess what I'm trying to understand is, too, without looking to the commentary, when the guidelines were first promulgated in 1987, there was no 2A 2.4. The statutory index for 18 USC section 111 listed 2A 2.2 and 2A 2.3. The aggravated assault in what was then called the minor assault guideline. Now it's 2A 2.3 is called assault. And so within a year, the commission drafted 2A 2.4 and then changed the statutory index to delete the reference to minor assault and substitute the new 2A 2.4 guideline. So in that sense, looking at the history, which we're supposed to look at under Kaiser or under kind of any type of interpretive review, we see that 2A 2.4 was really intended from the beginning to be more of kind of like a substitute for the minor assault or the regular assault guideline.
I'm not sure it's a substitute for regular assault because you still have 2A 2.3, which deals with the regular
Well, with
assault.
respect to section 111 in the cross-reference, it is kind of doing the work that the new guideline 2A 2.4 is doing the work that the simple assault guideline or the regular assault, minor assault guideline did before. You would agree with that proposition?
Except it has 2A 2.4 has an increased base offense level and additional enhancements. So I think that the Sentencing Commission created a separate category for these assaults against law enforcement officers. And I see
Can you
that.
lose if we apply Stinson? Can you win under Stinson?
I think we can still win under reasonableness.
Okay.
That
Well, tell me. Go ahead, tell me. Reasonableness argument.
that,
That's not the Stinson test, but go ahead.
well, it's inconsistent with the.
Okay, but that's a much different test than reasonable. So it's inconsistent with the guideline?
Well, that the commentary is inconsistent with the general common understanding of what aggravated assault is. Looking at the dictionaries, the model penal code, the treatises, state statutes, they all look at aggravated assault as involving significant violence or potential for serious bodily injury. And to the extent that the commentary.
That's accurate. I mean, I think there are dictionaries, like Black's Law Dictionary has a definition that defines aggravated assault as assault with intent to commit another felony. And there are states, there are plenty of them, define aggravated assault with as including the intent to commit another felony. Some of them enumerate the felonies, some don't, but it's just not uniform.
No, it's,
there.
but Black's also, after that, after their definition says, see model penal code 211.1.2, which does not include
But the model penal code
intent.
does not pretend to be, it is actually giving guidance on where it thinks the law should go. This provision does. It doesn't pretend to be codifying the existing state of the law.
No, but it was
That's really
promulgated.
important. for your point.
The model penal code isn't like a restatement, right?
No, but it is a, if you, the,
It's a model recommendation. It's not,
from 1962. And if you, going, states that have an offense captioned aggravated assault, there are only 3 of them that include intent to commit another felony in that category. You can have many different assault with intent to do something else that are an aggravated form of assault, but those are specific offenses, not as such as murder, robbery, rape, and kill.
what in Stinson says the commission couldn't go with those 3 states in Black's Law Dictionary?
There's nothing directly in Stinson, but the question is what?
Under the Stinson standards, what I meant, under the Stinson standard of review that we apply to the commentary, that's what we're bound by. How would we say that fits that Stinson's very, very narrow standard of review?
Well, I do think that it's inconsistent with the common understanding of
That enumerated
aggravated
as a
assault.
reason under Stinson for disregarding commentary? That it had to be inconsistent with the guidelines that are plainly erroneous.
Erroneous or inconsistent with,
Plainly erroneous if 3 states do it.
may not be plainly erroneous, but I think it's
It's not
inconsistent.
the guideline itself.
Well, I think it is inconsistent with the guideline because the guideline doesn't define the aggravated assault.
Going to be inconsistent with your definition and the guideline itself, then you could have inconsistency, but how can you be inconsistent with silence?
Because if in the absence of a definition, you look to the common understanding of what the term means. And that's what the Supreme.
That we do, that the commission must apply the common or most popular understanding.
I'm saying that the Supreme Court has said that when you're interpreting a term, you look to what the common understanding.
Under Stinson?
Generally under like Borden, that when you're looking at a term,
I'm just asking under Stinson because Stinson has not been, that's what binds this court.
well, I think that Kaiser does affect whether or not Stinson was binding.
Stinson
Kaiser did not directly overrule Stinson.
did it injure Stinson?
I think it modifies, and
Decisive section.
I think it modifies Stinson.
It does not modify Stinson. No sentence anywhere in there. All there is it's included in a citation to a long string side of citations, and then the court goes on to say we're not overruling it. There's no, I mean, at least from our perspective as a lower federal court of appeals, there's no language that we could point to that would say Stinson has been overruled.
No, but there's a difference between overruling and modifying. And
Oh, I don't think so. I mean, if you're saying it no longer, the standard is no longer the Stinson standard and it's now the Kaiser standard, that would be overruling Stinson standard. I'm just trying to understand how we could do that without getting in trouble.
well, so then under Stinson, if you look at, after you look at the text, if you look at the text can include assault with intent to commit felonies such as smuggling, illegal reentry of aliens, contraband tobacco. Those are not the kind of offenses that the courts have held to be aggravated felonies. There's no serious.
They held they are not?
There's no aggravated, there's no, if you look at the state statutes that define aggravated felony, the felon and include specific felonies
Well, that's
in
because the
that
states
group.
don't get to regulate immigration. And so,
Well, no, smug,
but I think the point is that what the committing a felony, sorry, assault with intent to commit another felony is going at is that it is, assault's bad. But if you do assault as part of, or en route to, or intending to, as a way of getting to another felony, it's a tool for committing another felony, that's worse than assault by itself. And I don't know that really turns on what the other felony.
it's worse, but if you look at 111, then you have intent to commit another felony, jumps you up to an 8-year maximum, but the enhanced penalty where you have dangerous weapons, serious bodily injury is a 20-year felony. So I think there is a distinction in 111 between the intent to commit another felony and the enhanced penalty, which I would argue is the equivalent of an aggravated felony.
Thank you very much. I will give you a couple of minutes on rebuttal.
Thank you.
Good morning, and may it please the court, Eric Hansford for the United States. While there is no single consensus definition of what an aggravated assault means, one traditional definition is the one that's used by the commentary, and that captures assault with the intent to commit another felony. That definition that's used by the commentary reflects federal law's treatment of the seriousness of that crime in places like Section 113. And I think as Judge Garcia's questions earlier, we're going to the clearest proof that that definition is proper is that cross-reference that's found in Appendix A for a 113A2 conviction. There's kind of no way to get past that and to rule nonetheless that this definition would be impermissible.
But when the guidelines were first written in 1987, there are 3 assault guidelines: assault with intent to commit murder, aggravated assault, and what they called minor assault. Within a year, they added a 4th assault guideline that is specifically called impeding or obstructing or impeding officers. So that is an assault guideline. It's within the group of guidelines for assault. It's now the 4th one. So if you just look at the text of the guidelines, and yes, there's a cross-reference to both the 2A 2.4 and 2A 2.2, but if you look at the text of the guidelines, isn't the obstructing or impeding officers guideline more apt for the mine run of 111 convictions?
So I think no, because you are not asking how, in the abstract, looking only at 111, how are we going to treat this? You also have to look at all the other places that the US Code captures assault with the intent to commit another felony. And that includes 113, 115, other places as well. The most common being the 113A2 conviction, which applies when you're on federal land and maritime jurisdiction, on tribal land. That's the most common assault with the intent to commit another felony. And for that one, the only place that the Appendix A tells you to look is into 2A 2.2 or certain sexual assault provisions that wouldn't apply here. But if you had an underlying sexual assault with the intent to commit that. But there's no cross-reference to 2A 2.3 or 2A 2.4 for a 113A2 conviction. And so I think that's kind of the clearest proof that this is where you're supposed to be looking for assault with the intent to commit another felony.
But what does 113A2 have anything to do with this, where the vast majority of those offenses aren't going to have anything to do with obstructing or impeding federal officers.
Because your question for interpreting the guidelines here is not, what do we do with a 111 conviction? Your question is, when you are looking at 2A 2.2 and it says aggravated assault, what does that mean?
No, the issue is whether, as between these two guidelines and this particular issue, this particular set of facts, which of these two, to the extent we can discern, unambiguously applies to this set of facts. I mean, we don't do ambiguity by just saying, is aggravated assault ambiguous or not in the abstract. What we do under Chevron or Robinson v. Shell Oil is we look at ambiguity in the context of the question we have to answer. And the question we have to answer is, between these two guidelines, guideline 1 and 2, which one is it? Isn't that the question?
I mean, I would say I agree you look at context, but I think the context you are looking at is the entire guideline book. You are not trying to.
The ambiguity that we are trying to resolve is the ambiguity with respect to this offense with these characteristics, right? I mean, we have said that a statute can be ambiguous for other applications, but it's unambiguous with respect to the facts that we have.
I'm not sure that your approach would lead to a different answer, but how I would think of it is you are looking at the text of the guideline, and the text of the guideline says aggravated assault, and then you're trying to figure out, is the term aggravated assault ambiguous, or in particular, is the commentary definition that is provided a permissible definition, genuine ambiguity, a reasonable resolution. I don't think these ultimately.
Are you saying that we just determine in general whether aggravated assault is ambiguous, or we determine whether it's ambiguous when you look at these facts?
Whether it's ambiguous as to assault with the intent to commit a felony, which is the specific definition.
While assaulting an officer.
But that doesn't, I mean, the fact that you are assaulting an officer doesn't make any difference to your guidelines application.
It makes a difference to whether you're convicted of 111 or not.
It does, but it does not, the guidelines commentary is not turning on whether it's a 111
We're
conviction.
supposed to look at the guideline itself first before we look at any commentary to determine whether there's ambiguity. That's my point.
You are supposed to, yes, I certainly agree to that. And you look at the full guideline. And so you are trying to figure out what does the term aggravated assault mean? And in particular, does it capture assault with the intent to commit another felony? And that is a traditional definition of what aggravated assault is. And it is clearly provided by the cross-reference. I did want to touch on the model penal code quickly, because that was.
I think I thought that the way that this exercise went is we have an offense of conviction, which is 18 USC 111. And we have the basic facts of that conviction are that a law enforcement officer was struck and with the intent to commit another felony. And so the question is, with those facts, that being the issue, do we pick 2A 2.2 or 2A 2.4? And just looking at the text of those guidelines, not the commentary of either, just the text of those. Does either one of those unambiguously seem to be the right guideline? Is that the exercise we're doing? At least at the first step?
I don't think so. I think I think most of the steps you laid out are how I would approach it. But then the question is, what does aggravated assault mean in 2A 2.2? And in trying to figure out what aggravated assault
But
means.
why do we go straight to that where the sentencing index says you look at, it could be one or the other?
Well,
Do we
because
have to look at the guideline itself to figure out which of those two? Is it 2A 2.2 or 2A 2.4?
I don't understand how you would resolve that question without figuring out what aggravated assault means. If it points you to 2A 2.2 and 2A 2.4 and 2A 2.4 specifically says, if this is an aggravated assault, use 2A 2.2.
So you're referring to 2A2.4 C1, right?
For-
If the conduct constituted aggravated assault,
Yes,
refer to 2A2.2.
yes,
Okay, so you're saying we can't apply 2.4 without deciding what aggravated assault means?
that's correct.
Okay.
Yes, Your Honor. Yep. And so I think ultimately the challenge here is whether or not you're applying what does aggravated assault mean? And the definition that's being used here by the commentary is consistent with treatises, consistent with Blacks, consistent with how federal law views the seriousness of this crime. And so we do think that it was appropriate here what the district court correctly applied the guidelines in this case.
How does it cut that Congress kind of had that the commission had three gradations of assault initially: minor assault, aggravated assault, and assault with intent to commit murder. And then they add a fourth, this obstructing or impeding officers as a gradation of assault. I guess the argument could be, well, before, aggravated assault just kind of would seem to be anything kind of in between minor assault and assault to commit murder. But now they have kind of the second category of assault that's like in between those two extremes.
So
Is that cut?
I think it's not correct to see it as an in-between category of assault. Instead, it's a category of assault for a particular set of circumstances, which is when the victim is a federal officer. But it's not like there's, when you threaten a dangerous weapon but don't use it, or there's a less serious injury. It's not that category of crime. It's instead just for the specific circumstance. And so I don't think that the decision to add this extra category to deal with times when you are assaulting a federal officer tells you much about the meaning of aggravated assault. And again, you've got to figure this out, not just for a 111 conviction, but for a 113 conviction, a 115 conviction. And under those provisions, assault with the intent to commit another felony, if you look at 113 assault.
Maybe the way it's working, it's for simple assault, but if you do simple assault against officers or otherwise use assault to obstruct them in their duties, they wanted that to be treated differently than simple assault on everybody else. But at the same time, if you assaulted an officer with the intent to commit murder, no one would think that you have to do the 2A 2.4 instead of a murder one. And
That's
so
right.
when you've got, it's one thing if you assault the officer because you just don't like the officer. But if you assault the officer because he or she's in your way as you're trying to commit another felony, then that would, at least with some, judgment by the district court, easily fit into the aggravated felony context. So at some point it's, this one is, the officer one is meant to recognize that assaults can be worse because they're against an officer, but they don't become less serious because they're against an officer.
That's right. And that's reinforced by that cross-reference in 2A 2.4 C1 that says, if this is an aggravated assault, use 2A 2.2. Yes, we certainly agree.
Can I
No, go ahead.
just wanted to ask a question about, we had some questions about this debate between Stinson and Kaiser. And I'm just curious what in the government's view is practically at stake in that debate. The Fifth Circuit had a long and interesting opinion about this. And then it concludes by saying, we actually don't think the level of deference makes any difference. The majority and the dissent both say that, and several other cases say that. Is there some category of case that you think the government thinks come out differently under Stinson and Kaiser?
So I think, so just preliminarily, I think this is not the case that where the level of deference would make a difference. But no, we don't view those as different, because I think taking a step back, when you are looking at Stinson, what Stinson is saying is we are going to apply our /Seminole Rock deference and to the guidelines commentary. And then Kaiser goes up and says, we are going to keep our /Seminole Rock deference. We are going to maintain that under stare decisis principles. And we are going to reiterate, reemphasize, restate, that's the vocabulary that the Supreme Court is using. We are going to reiterate the already existing limitations of that deference. So in other words, the Supreme Court is saying on its face, this is not a change in terms of the level of deference that's being afforded. This is just the application of our /Seminole Rock deference. But some of the language, if you take it in isolation, can look very loose. And so we want to reiterate the already existing limits that are within that deference. So in other words, the Supreme Court on its face is saying, this is not a change in the law. This is not a change in the level of deference. And indeed, the main point of the opinion is under stare decisis principles, we are going to keep that old our Seminole Rock deference. And I think that's made especially clear by the fact that Kaiser does cite Stinson among the many cases that is applying this our Seminole Rock deference in the plurality.
But there would be a huge difference, because Stinson wasn't an ordinary our situation, because it was dealing with the Sentencing Commission. And they were clear in Stinson that you don't even need ambiguity to be bound by the commentary. But of course, you do need ambiguity under ordinary our and under Kaiser. And so there is difference between Stinson and all of the other ordinary executive agency applications of our /Kaiser review. And so it seems to me there is a material difference, maybe not in this case, but there's real difference between Stinson and Kaiser, at least as to whether ambiguity, let alone genuine ambiguity, is required. And so I'm curious why the government has taken the position that Stinson is now overtaken by Kaiser, when they're different in that regard. The Supreme Court has not overruled Stinson, and the Supreme Court has said courts of appeals shouldn't be getting ahead out over our skis when the Supreme Court hasn't yet overruled something. So I don't understand why on earth the government is arguing for a Kaiser view in the sentencing guidelines context.
So I similarly don't want to get out over my skis, because this position is not articulated by our office. It's coming from the department and the Solicitor General's office. But from my understanding, it is what I said earlier to Judge Garcia, which is that
it's not
Stinson,
accurate, because I mean,
Well,
I understand what you're saying. I mean, Stinson requires no ambiguity, and everything that you said about our and Kaiser requires at a minimum ambiguity.
So I think there are two things to say to that. One is that the commentary can do various things. The commentary is not just clarifying when the guidelines apply. The commentary can also give background information. The commentary can generally describe things. Stinson goes through this. So in other words, the commentary is not limited to the situation of clarifying what the guidelines mean. But then I think the other point is
But you only get this question when someone's applying the commentary to understand the meaning of the guideline itself. If it's just a bunch of history, that's not going to, unless it's used as interpretive history, it's not going to be raised in this context.
So maybe the other point goes to it, which is that Stinson, what Kaiser says is we are continuing this level of deference, this our Seminole Rock deference. that Stinson says it's applying. So the only way you get to these concerns about,
No, Stinson said kind of like.
Well-
Recognized it was really different. It really-
no, I think Stinson says the situation is kind of like, the situation with the guidelines and the commentary is kind of like regulations or
Kind of like.
closer. No, it doesn't say kind of like, but I forget the
I know
exact
there's
phrase.
no
I'll
language
let you
like that, but
Analogy
Right.
is imprecise.
Right,
Good,
right.
thank you.
But then what Stinson says is that it is going to adopt that level of deference when applying the commentary. So in other words, it's saying it's not a
Except
perfect,
Stinson also says you don't have to, you always had to have ambiguity for our when it dealing with executive branch agencies. Which under Stinson, you never had to have ambiguity. That's my only point is that it really seems like you're a little bit mixing apples and oranges.
It isn't the answer to Judge Millett's question that the Supreme Court basically kind of exercised what we might want to call a little bit of kind of revisionist history, in the sense that it says in its footnote that the pre-hour decisions applying Seminole Rock are legion, and it lists Stinson as one of them. And it previously described Seminole Rock as deferring only when there's ambiguity in the regulation. So the Supreme Court seems to be kind of pretending that Stinson was a faithful application of Seminole Rock when it wasn't, to try to harmonize it with what it was saying in Kaiser.
I mean, I don't think I want to say that the Supreme Court was misleading in terms of how it was deciding the case. I think instead it's that the Supreme Court was recognizing in Kaiser that certain statements out of context might be misleading in terms of how our or Seminole Rock deference is supposed to apply.
You don't have to say it the way I said it. I probably shouldn't have said it the way that but I don't care. You should care. You can say it was a refinement.
Well, I think I think the language that they're using is it's a restatement, it's re-emphasizing these already existing principles. And if you take seriously what the Supreme Court is saying, what the decision is saying on its face, I think it does follow that that restatement is going to apply wherever our Seminole Rock deference is applied, which does include.
I take them very seriously, but I also take seriously when they say, don't read us as overruling precedent until we said we're doing it. And I also take quite seriously that the Stinson they cited dealt with a commentary that hadn't gone through notice and comment. And now virtually all notice, since 97, almost all notice and all commentary goes through notice and comment, which completely changes the game. Then you're not even in our land to begin with, which is why the government's position is very confusing to me. But you.
Again, it is the department's position on that. Yes. No further questions. We'd ask the support.
Let me just
Sure.
ask you this. When a guideline is written like 202.4, it includes a cross-reference in the guideline itself, not in the commentary, to, the aggravated assault guideline. And the aggravated assault guideline is pre-existing. It's not, so in 88, when 2A2.4 was first written, we already had the aggravated assault guideline. And it already had a commentary that defined what aggravated assault is. I mean, shouldn't that count for something, that the commission in drafting the guideline referred to a previously kind of like approved commentary, and a commentary that had in essence kind of been reviewed by Congress as part of approving that prior aggravated assault guideline? Shouldn't that be a thumb on the scale somewhere?
It does seem like it should be, and it seems in some ways analogous to a situation where you have, a amendment to a statute where you already have kind of a consensus on what the prior case law means. It seems analogous to a situation where you are looking to what the already accepted meaning is, and you are kind of potentially incorporating that. So yes, I do think that would meaningfully push towards applying that commentary definition as well. If there are no further questions, we'd ask this court to affirm.
Ms. Misner, we'll give you 2 minutes.
Thank you. The purpose of the guideline provisions 2A2.2 and 2A2.4 are to provide guidelines for the appropriate punishment for violations of Section 111. And so for that, I think you have to look at the structure of Section 111. You've got the 111A, which is a misdemeanor and simple assault. Then you have the felony provision in 1A, which is physical contact or intent to commit another felony. And then 111B, while it's not titled aggravated assault, is an aggravated version of felony assault, serious bodily injury, dangerous weapon.
The assault and intent to commit felony is subject to 8 times the punishment of simple assault. So Congress definitely wanted some differentiation between intent with committing assault with the intent to commit another felony and simple assault, correct?
Correct.
And they added that provision to 111 after the commentary had been written and was in place.
But then you have 111B, which has an which provides for not more than 20 years, where you have serious bodily injury or dangerous weapon, which are 2 of the criteria in 2A2.2 commentary definition. The guidelines created different structures than the statute, and I think you have to take into account
But there's a
that
lot
this
of
is a statute. that-
enhancements or increase in levels, I should say, for the types of things that are in B in 2A2.2, right?
Yes.
So-
And you also have enhancements in 2A2.4 for bodily injury and dangerous weapon.
Sure, but they're
But on-
more substantial.
And on your view, simple assault officer is treated exactly the same under 2A2.4 as assault with intent to commit another felony on an officer, right?
No, it would be assault with physical contact.
Right.
Is different from, would
If you
be
had an
the
assault with
same.
no physical contact, but with intent to commit another felony,
Right,
that would
then
receive no increase under 2.4, right?
it would increase it increases the base offense level. 2A2.4 increases the base offense level over simple assault.
Simple assault on an officer. They would both receive a 10, right?
Yes,
So I'm getting at the incongruity between your view and how 111 works. 111, as Judge Millett pointed out, says it's 8 times worse to have an assault with an intent to commit another felony. And under your view, the guideline treats it exactly the same as if there's no such intent. Maybe that's a little circuitous, but.
well, I mean, I think that the guideline takes that into account by having the base level.
Okay,
Base
thank
level is
you.
the same, whether there's any,
No, but from
Okay.
differentiating from the simple assault.
You mean the 2A2.3
Yes.
guideline
Yeah.
for
right.
assault, minor assault, or regular assault?
The
And
2A2.4 says pushing an officer, just for the sake of pushing an officer, will be treated the same as pushing an officer out of the way so you can shoot somebody else.
yes. But I think then, and just looking at 113, I think that there's so many differences between 111 and 113 that you can't automatically say because 113 has intent to commit a felony as in one category that carries over to 111. 111 puts contact and any other felony in the same category. 113 puts contact and any other felony in different categories.
Okay. I think there's no more questions, so thank we understand your arguments. Thank you very much.
Thank you.
Case is submitted.
Case number 22-1288 et al. Cadillac of Naperville, Inc. petitioner versus National Labor Relations Board. Mr. McHarg for the petitioner, Ms. Campbell for the respondent.
Good morning.
Good morning, Your Honors, and may it please the court. My name is Michael Patrick McHarg, Sr. on behalf of Appellant Cadillac of Naperville. I think as Your Honors are well aware, this case has what could best be described as a Byzantine procedural posture, having been here once before, remanded, reversed by the board, brought back, and then in the middle of my appeal, changed by the board yet again. Nonetheless, here we are. But really, to me, this case comes down to,
You haven't argued for another remand.
we are not
You don't want to
arguing.
do more.
I think, to be honest, Your Honor, we think we can win either way, but B, I don't want to mislead this court. I think my client has some litigation exhaustion. So we'll just make our argument and understand where we are. Under any standard, you know, I know line of last emerges before the Fifth Circuit. So we're on, you know, perhaps even the board standard remains unclear, but we're still just dealing with common sense in the workplace. What kind of behavior can an employee get away with and be left without punishment? You know, under the Atlantic standard, you have this question of where's the place? Well, the law is inconsistent on that. On the one hand, they say inside the office, it's heads we win, tails you lose. In an office, we win. Outside an office, we win. Then the question comes up of the subject matter. And then to us, we take most seriously the subject matter of, the nature of this outburst. What happened here was extreme and directed at the owner of the company in his very own office. The board has never, under either time, the board failed to take into consideration exactly what happened in that office.
And just to be clear, when you say under either standard, there's no different arguments you would make under an Atlantic Steel than Right Line. You're making the same points here under both, that you should win under either standard.
That's correct, Your
Nothing
Honor.
else that you would argue if officially we were applying Atlantic Steel.
No, Your Honor.
So under Right Line, right, there's two steps. Prima facie case that the action of discharge was out of animus, and second, whether the employer would have fired the employee anyway. And it seems to me what you've been saying today fits mostly in the second bucket, that because of the severity of this statement, you would have fired him anyway. My question is, are you making an argument that there is no evidence of animus that the board could rely on for the prima facie for step one under Right Line?
If we were analyzing the case under Right Line, I believe that we have demonstrated that there was no nexus, that the board relied upon a June 29th conversation for, I believe it was a September 17th discharge, a throwaway comment that.
So I agree we can nitpick about some of the pieces of evidence. And in this footnote, the board cited 6. The one that really stood out to me is just what happened on the morning of the firing, right? Bispicus comes in and I hope you forgive me for paraphrasing, but Lascaris basically says, you've been the ringleader of this strike and I don't want you to work here anymore. It seems pretty explicit statement that he is not a fan of Bispicus because he's participated in the strike.
Well, he was discussing that with the entirety of the union leadership, right? The business agent was there, the president of the union was there, Mr. Bisbicus was there. Lascaris is trying to negotiate to remove all of the strikers at that time. So you're correct, Your Honor. He was telling them that he was trying to offer some sort of settlement to get them to go elsewhere to work. That is correct. And then Bisbicus calls him a liar. Frank gets angry, and then the whole sideshow starts.
But it's not
I'm sorry?
just settlement. The concern from the board was that Mr. Lascaris was explicit that he doesn't want any union members working in his shop now. Any union members that went out on a strike. He doesn't want any of them there.
That's correct. The conversation was hostile.
Is that evidence of animus towards their exercise of their rights under the NLRA to both join a union and engage in collective action like a strike?
I do not deny, Your Honor, that it is more likely basic case.
Okay. They're on animus.
Sorry?
On animus.
That's correct.
Okay. So in response to Judge Garcia's question, you are just focused on we would have fired him anyhow.
We would have fired him in any event. That's correct. It would be a difficult case for us to say that there was no prima facie case.
I'm just trying to make sure I understand the context completely here. It's not that the way that the board's analysis went, it's not the case that Hibiscus, I'm butchering his name, I'm sure, that his behavior couldn't be subject to any discipline, right? They weren't saying that under Right Line or Atlantic Steel, like nothing could be done to him. The question was really whether the termination was appropriate, right?
That's correct.
And so how, I guess, how do you win when there was no evidence that the company had ever terminated anyone for saying anything similar and that the company never produced a code of conduct that would justify termination?
I understand your question, Your Honor. As we have stated, I believe in both of our briefs, there's certain conduct that you simply aren't going to be able to replicate. There are certain things that a standard of conduct is not necessarily, as we argue in our brief, going to say, don't commit a felony or wear pants to work. But if you violate certain common sense principles, you're going to lose your job, right? I had a situation once where a guy was cleaning his rifle at his workstation. We didn't necessarily have a don't clean your rifle at work and point it at your coworkers, but
Did you have any code of conduct at all, though?
I believe there was a written code of conduct. I don't believe we submitted it into evidence. It was 7 years ago. I don't recall. I'm sorry. I believe we just dragged the code of conduct out through the testimony of Mr. Lascaris, and screaming a vile epithet, climbing around his desk. We thought at the time warranted summary termination.
Finding of screaming or climbing around his desk. The ALJ found that he sort of muttered this on his way out the door. Are you challenging the ALJ's fact findings?
We can't do that really. It's a practical matter. I don't think he found it as a mutterer. I think he found that it was.
He was on the way out the door.
He said on the way out the door was the discussion between the business agent and the employee about whether or not they heard the discussion between Lascaris and Mr. Bisbicus.
Questions?
Question?
Do you have anything to add?
No, we'll wait for rebuttal, Your Honor. Thank you.
Thank you.
Greetings, Your Honors, and may it please the court. My name is Elizabeth Campbell, and I represent the National Labor Relations Board. After a highly contentious strike, Cadillac of Naperville fired Mr. John Bispikis, who represented the company's mechanics as their union steward, while he was attempting to negotiate return to work procedures. The evidence of the company's hostility towards Mr. Bispikis' union activity is overwhelming. In the 6 intervening years, the board's conclusion has never wavered, that the termination of Mr. Bispikis violated Section 8A3 and 1 of the National Labor Relations Act. It is long past time to remedy that violation.
You would agree that that the company could have been justified in disciplining Mr. Bispikis, right? Imposing some discipline, right?
Your Honor, I can't speak for the board on what it might have done had the employer disciplined in a lesser manner.
I'm not asking you what they might have done, but that would be a reasonable action that could be sustainable under board law.
Under board law, an employer can discipline an employee for misconduct. Full stop. That's not really a question. An employer's not forbidden ever from disciplining an employee from misconduct unless it's done, with anti-union animus, or unless the employee retained the protection of the act under the Atlantic Steel analysis at the time when they engaged in the discipline.
What I'm a little confused about is, so came here last time and you said you're supposed to apply bright line. The board did Atlantic Steel, and then the board changed its mind and said we're going to do right line, and we remanded for right line. They applied right line, and now it comes here again, and now they're saying in line elastomers. Actually, we're going back to Atlantic Steel. And line elastomers said not only are we going to apply Atlantic Steel, we're making this decision retroactive, which means line elastomers applies to this case. And so how can we, he doesn't want to, y'all treat him like a ping pong ball here, right? They don't want to keep going back and forth. But you all keep changing the rules of the game. And this is agency review, not district court review. And it seems hard for me to understand how we can uphold a decision under right line when the board has said that's not the correct law anymore.
I understand, Your Honor. I think in terms of the retroactivity analysis, board law is quite clear that when the board makes a decision that's retroactive, that absolutely applies to all cases pending before the agency.
It applied to cases pending in court?
The board has discretion to ask for a remand when a case is in court, when the agency issues a change in law. Here, the agency acted very reasonably. I think this court would agree, given the fact that this is a very unique set of circumstances. So in particular, you're right, Your Honor, the judge here originally applied right line. And right line itself remains good law. I would note it's correct. It would not necessarily be applied in cases like this moving forward, but a right line motive analysis is still a proper way to find a violation under Section 8A3 and 1. And so in that sense, that makes this case unique. And in addition, this case is also unique in the sense that the standard that the board has now adopted in line elastomers was a pre-existing standard. So Atlantic Steel has already been applied in the facts of this case in the 2019 decision and order before you. That's a very unusual stance when the board or any agency changes law. It's not very typical that the law that it changes to has already been applied to the facts before the court. So in this case, the agency did choose and exercised its discretion to stand behind the decision and order before you, analyzed under right line. And I think it's important to keep Mr. Bispikis in mind. I think the concerns about his failure to receive the remedy to which he is entitled under the act, another remand would not be in the interest of justice for him, for this court, for the
We also
board's
need to keep
resources.
the employer in mind too. They shouldn't be drugged through round after round after round after round. It's not, I understand your point about Mr. Bisbicus, but it's also for the employer unfair when the board keeps changing the rules of the game.
Correct, Your Honor, which was another reason to stand behind the decision and order before this court, which is under right line. I'll note that the employer has, from the very beginning, in its very first brief, post-hearing brief to the ALJ, has asked for right line to apply to the facts of this case. It continues to not insist on a remand, and right line is being
We're
applied.
supposed to apply on appeal the law in effect at the time of the appeal. That's where I understand the arguments in that case, but so you're asking us to apply the law that's not in effect at the time of appeal? Or are you asking us to decide this under Atlantic Steel based on the prior application of Atlantic Steel?
I
Or
believe
decide it's on the ground that it doesn't matter either way. Either they win or you win either way.
my answer to your question, Your Honor, is yes. I think you can do any of the above. Here, right line itself remains good law. Right line is an unlawful motivation.
Situation.
Correct, Your Honor, but the board has had opportunities to apply both.
But I thought an answer you said earlier would mean it's the right test for this case, because you said when the board declares one of its decisions retroactive, that's only retroactive as the case is pending before the board. And this case was final and on appeal when this new decision came around, right?
Correct, Your Honor. Well, I want to be very careful with my language here.
I appreciate you still would have discretion to ask us for a remand,
Correct.
but it does not apply of its own force in a court.
There is an understanding that when, for example, the record is filed with the court, the board doesn't have jurisdiction. So that would be an argument. I would not want to suggest that the board would not be able to seek a remand if it wanted to. However, in this case, the agency has chosen not to seek a remand, and for good reason, and stands behind the decision and order currently before this court. That being said, if this court is uncomfortable applying right line and General Motors, given that line elastomers is good law, I think the Wyman-Gordon case law that is good law across the circuits and that the DC Circuit has relied on repeatedly, which is that if this court were to remand, it's a sort of similar to a harmless error argument. Sure, the maybe now you could argue now the analysis that should be done in a case like this is Atlantic Steel. But so this court then remands again for the board to apply Atlantic Steel again. Really, it's clear from the record, and I don't think there's a reasonable doubt that the board, if it were to apply Atlantic Steel, would come to the same reasonable conclusion that the employer violated Section 8A3 and 1 here.
I appreciate your point about filing the record, but actually in the NLRB, the cases aren't filed because they're unenforceable until a court grants enforcement or not. And you have a cross application here for enforcement.
Yes, Your Honor.
And so the board's view is that the cross application for enforcement should be decided under right line or Atlantic Steel?
Your Honor.
Both.
Yeah. Your Honor, the board stands behind its decision under right line and an unlawful motivation analysis. That being said, should this court feel that...
I'm asking the board's position on what basis it believes this court should, because you've asked for an enforcement, or you've got a cross application for enforcement.
Yes, Your Honor.
Now, they might win and we'll all be moot, but you've asked for enforcement. And so what is your position on the legal rule that should be applied given line elastometers for the cross application for enforcement?
Your Honor, the agency stands behind its unlawful motive analysis under right line as a finding of a Section 8A3 and 1 violation. The agency also believes that this court can look at the writing on the wall, look at the record in this case, and know that the agency would come to the same reasonable conclusion were it to apply the current standard, which is line elastomers, which would again be, which this court has repeatedly upheld cases decided under both standards. And so the agency does stand behind its decision and order before this court. You know, I'm not, Chenery might forbid me from saying, just go with Atlantic Steel. And we want to be conscious of that. And we want to be aware of that. And therefore the board does stand behind its unlawful motive analysis. However, I think the Wyman-Gordon and those other exceptions that I cited, the Wyman-Gordon exception that I cited about not turning, like Your Honor said, not turning an agency's decision into a ping pong game with the courts. There's no reason to remand this case and have it decided again under the board's current standard, given that the record is quite clear that the agency would come to the same reasonable conclusion. If there are no further questions, Your Honor, I thank you very much for your time.
Thank you very much.
Thank you.
We'll round up and give you 2 minutes.
Thank you, Your Honor. I would just say as to that last comment, I'm a little nervous about conceding that we can just assume that the board would do the same thing with this case. I mean, the fact is they never did. To your question, Your Honor, about is before this court, this case was remanded to the board and was before the board at the time Lyon Elastomers was decided. So Lyon Elastomers retroactive application, their cross enforcement is on the Lyon Elastomers standard. But back to our original argument.
The board has applied both Atlantic Steel and Right Line to your case. You're here challenging certainly the latest decision under Right Line, but they've applied. First time they applied Atlantic Steel and you said apply Right Line and you got what you asked for, and now they've applied Right Line. So I think all she was saying is the board has already applied both. So, and you said your arguments as to error, which are before us, are the same under both tests. So,
and I stand by that. As this court held in Felix Industries and then later in AdTrans, there is a way to get to decency in the workplace. AdTrans court, the union took the position it's perfectly acceptable to use the most offensive and derogatory racial or sexual epithets so long as that's connected to union organizing. And it's unfair to expect members to comport themselves with civility and decorum. And the court went on and said, working people are capable of discussing matters intelligently and in generally acceptable language. That overarching principle applies here. This is a case about workplace decency, about not tolerating insulting attacks and attack. Had that been
at least by mechanics, but Mr. Lasarkis had some pretty ripe language himself before he spoke. So it's a little hard to say that foul language is not tolerated in the workplace, unless it's the point that it's only tolerated by Mr. Lasarkis.
Not at all, Your Honor, but if I stub my toe and yell something, that's one thing.
It was directed to Mr. Bespikis, because it was, you get the F out of here or I'm going to F you out of here.
That was after Mr. Bespikis called him a liar. I don't recall if he swore or not. And there was an argument in his office.
That's how they disagreed on recollections, but that wasn't, Mr. Bespikis had not used any foul language at that point.
Okay, but.
And I'm just trying to ask this because you've talked about, and it's a relevant concern about the ability, at least when it comes to sexually and racially derogatory language of employers, to ensure that they have a working workplace atmosphere that is free of such hostility. But I thought this is a case of just sort of ordinary profanity. And I'm trying to understand what your description of the workplace is, because it certainly doesn't seem to be one where profanity is not used.
Not saying an auto repair shop would be. There's a difference between profanity and directing the profanity at somebody.
Which Mr. Lasarkas did too.
He told him to get out of the office. I'm going to,
Right.
I'm not going to repeat it.
Bleep, bleep, bleep.
Right, no, I mean, he did swear, but he didn't insult Mr. Bezbikis directly. He didn't say something that would have threatened him or demeaned him. And the board has held since the 80s, insulting attacks need not be tolerated. Thank you to this panel. We ask for reversal and happy holidays.
Case is submitted.